You brought a medical malpractice lawsuit against your doctor claiming that he was careless and caused you significant harm and injury. During the course of your case, your attorney tells you that the judge is seriously considering throwing your case out. If the judge throws your case out during the course of your discovery period, can you still go forward to trial and present your case to the jury? You want to know the answer? Come join me a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is no, you can't. If the judge throws your case out during the middle of discovery, your case is done. It's finished. Your only option may be to appeal the judge's decision. So now, how could this come about? Well, during the course of your lawsuit, the defense may turn around and realize that you don't have a valid basis for a case. And rather than wait out the entire 2 to 3 year duration of the entire lawsuit process, they say, you know what? We have enough information to go to the judge to show him that you don't have a valid basis for a case. That's known legally as making a motion. A motion is a request for the judge to take some action. A motion for summary judgment. Summary judgment just means that they want a decision in their favor right now. That's it. Without testimony, without going to trial, judge, give us a verdict in our favor. That's really what it means. Give us an order, give us a decision. Now, can they do that? The answer is yes, they can. They can make a written request to the judge saying, Judge, we believe that the injured patient has no basis for a case here. Let's explain why. Let us tell you why. And now they have to show the judge in proof, in admissible form. What does that mean? It means that they have to show the judge using various medical records, using various testimony, using various affidavits from their experts. They are using the same exact proof that they would have to use at the time of trial, but they're doing it in a much earlier time period. Judge, look at all these records. Look at what our qualified medical experts have to say. And now your attorney is going to have to rebut those arguments. He's now going to have to get his own medical experts, and he's going to have to put in his own proof to show that in fact you do have a valid basis for a case. So now let's assume for a moment that the judge actually decides in favor of the defense and says, no, I'm sorry, injured patient, you don't have a valid basis for a case. Your case is dismissed. Well, that's it. That's the end of your case. You get nothing. The jury will never get to consider or listen to any testimony that you've had. The jury will never evaluate whether or not you are more likely right than wrong. You want to know why? It's because the judge has already done that. The judge has determined, based upon the proof that was presented to him early on in the lawsuit process, that you did not have a basis for a case. And there could be many reasons for that. Maybe your expert was not qualified and unable to give a valid reason why you have a valid basis for a case. Maybe there was some information missing that the judge did not see that tipped the scales in favor of the defense rather than in favor of you. So now your only option may be to appeal it, and you have to discuss that issue with your attorney to see if there's even a legal basis to appeal the judge's decision. Sometimes there is, sometimes there isn't. And now you're stuck. But to answer the question I raised at the beginning of this video, can you get to the jury if the judge throws your case out during the course of discovery? The answer is no, you can't. Your case is done and finished. And if you choose not to appeal it, that's it. You're finished. So why do I share this information with you? I share it with you because this comes up often. The defense turns around and says, hey, you know what? We want to try and make an effort to get your case thrown out before going the distance, the 2 or 3 years down the road, and having your litigation go all the way to trial. And if they can try it and get 2 bites at the apple and get the judge to try and get this case dismissed, hey, they're going to try it. And now if they're unsuccessful, they're certainly going to try it at the time of trial as well. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I recognize and I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.